What if the house is in both spouses' names and there's adult kids on both sides? Here in Florida, when a married couple buys property and they own it as a married couple, it'll actually say that on the deed. It typically says as a married couple or as husband and wife. That means that the property is called tenants by the entirety's property. And that type of property passes outright and totally to the surviving spouse. So whatever spouse ends up passing away first, the surviving spouse takes 100% ownership of the property. So once the surviving spouse has 100% ownership of the property, then the property would trickle down to that surviving spouse's kids if they don't have a will or they don't have anything set up, or if they have some estate planning in place, if they have a will or if they have a trust, then the property that they now own is going to go to whoever they list in their will or their trust. Now, it can get a little trickier if both spouses die simultaneously and there's no way to determine which one passed away first. Then we are looking at an instance where the property could be inherited by the 4 children, because you have 2 children on one side, 2 children on the other side. However, the more likely occurrence would be that one spouse would pass away, and then that property, which is held as tenants by the entirety because it's a married couple, that property is going to be owned wholly by the surviving spouse, and the surviving spouse gets to dictate what's going to happen with the property after they die. I hope this helps. If you have any more questions like that and you are in Florida, please contact our office at atCause Law Office. The link is in my bio.